Thank you. Please be seated. Last case on the docket today is 1524-110. Ken Paxton, Attorney General versus Fiel, Houston. I may be mispronouncing that, but I'll let you correct me. Who's present for appellate?
Abby Smith for the state of Texas.
And for appellee?
Chief Justice Carlos Soltero for the appellee Fiel. Together with us also is the Executive Director of Fiel, Cesar Espinoza, as well as my co-counsel, Nina Perales.
Great. Thank you for joining us at the law school this morning. Ms. Smith, you may proceed.
May it please the court. Fiel's charter that it filed with the state of Texas covenants to abide by certain restrictions and limitations. Specifically, it states that Fiel may not, under subsection H, engage in more than an insubstantial degree in the carrying on of propaganda or otherwise attempting to influence legislation. It also covenants that Fiel shall not directly or indirectly participate in or intervene in, including the publication or distribution of statements, any political campaign on behalf of any candidate for public office. Fiel made that covenant to obtain significant federal and state benefits. Yet for the past several years, Fiel has devoted a substantial amount of its time and press statements to lobbying for and against immigration legislation, and has repeatedly issued calls for its supporters to vote for or against particular political candidates based on their immigration stances.
So is there any civic 501c3 organization does that? Is it illegal and is it a crime?
This is not a criminal violation. This is a civil violation. It's violating so here Fiel is doing two separate violations. So the first is that it's violating the terms of its own creation, the limitations that it covenanted to abide by in its corporate charter. And second, it's violating Texas state laws under the tax code that govern charitable organizations. Both provide grounds for quo warranto, which is the relief sought in this case.
And what is there, assuming your main point is correct, are there any remedies other than a quo warranto proceeding?
So there are, the Attorney General's office is empowered to seek quo warranto relief. The Texas comptroller in charge of taxes may also have its own procedures that it could pursue. The IRS could.
Yeah, because you have to apply for tax exemption, and I suppose they could deny it. Do they have hearings on that, or?
I am certainly no expert in IRS procedure. I believe that is correct. But with regard to the Attorney General's office, what the Attorney General is empowered to do, and what under the Texas Constitution it is required to do, is to monitor state corporations to consider whether they are violating the law, including complying with their charter. And if they are not complying with their charter, the Texas Constitution and several state statutes say that the Attorney General shall seek revocation of that corporate charter.
If they did not mention 501c3 in their corporate charter, would there be a proceeding like this?
There would still be a proceeding for a couple of reasons. So I have the charter before me that's at CR 42 and 43. And you're right that under Article 2, it states that they will be complying with 501c3 and Texas Tax Code Section 11.18. But then separate from that, under the limitations section, it does say this language that they will agree not to engage in more than insubstantial propaganda. They agree not to intervene in a political campaign at all. And so while that language is borrowed from the CFR regulations regarding 501c3, they are independently covenanting to abide by that in their own corporate charter. And as displayed in the record in this case and in the state's original petition, Fiel has violated that limitation in its own corporate charter. And to be clear, Fiel has never at any time denied any of this conduct. And that authorizes the Attorney General to seek to revoke Fiel's corporate charter.
So 61.001, I take it as the authority for the quo warranto proceeding, right? Y'all are going under subsections 4 and 5?
The quo warranto authority is codified at a few places. One is 66.001, 4 and 5. It's also discussed in Texas Government Code 402.023.
Okay. Well, 6101, the later sections specify remedies on a quo warranto proceeding. And I don't see anywhere in there that the corporate forfeiture of their charter is listed.
So
Could you
that,
address that?
yes, so that would be under Texas Government Code 402.023. That section is titled Corporate Charters. It says, unless otherwise provided by law, the Attorney General shall seek a judicial forfeiture of a private corporation's charter if sufficient cause exists.
Right, but sufficient cause exists is different than what you have to show for a quo warranto, and that's what I'm a little bit of a procedural nerd, so I'm trying to figure out how we get to where you're wanting to go. I could see injunctive relief, I could see, of course, you have the right to investigate, things as Attorney General, but we're actually talking about, they described it as a death penalty, I think they're right. Where's the authority for that?
So it's codified in a couple different places and discussed in a couple different cases, so I'll run through them. So for example, Texas Business Org Code, Section 2.113, limitation on powers, and that's the exact kind of limitation that is present in Fiel's charter. It says that this subchapter does not authorize a domestic entity to exercise a power in a manner inconsistent with a limitation on the purposes or powers of the entity contained in its governing documents. And that is the exact kind of exercise of a power of law listed under 66.01, a power that they are not granted by law. Multiple Texas cases have allowed the Attorney General to seek charter revocation under just these circumstances.
And while we're talking about the other cases, we know that the Texas Supreme Court recently heard argument in Annunciation House. Are we bound by what's going on there, or is that?
So the argument in Annunciation House, as you mentioned, was on Monday. The ruling will not come out for a long time. I don't think this court is required to wait for that ruling to come out. But I can say I was at the argument. Quo warranto was discussed. It was never discussed as to whether quo warranto was valid or not. The main focus was, can you use quo warranto against a religious entity
Sure, it's a
under
different-
Texas RFRA? And obviously, RFRA is not at issue in this case. So I don't think, while quo warranto is at issue there, and the exact same procedure was done in that case as was done here, seeking charter revocation under 66.001, ultimately, I don't expect that opinion to have much influence on this case because the focus really seems to be on the religious nature.
Well, that case is alleged unlawful activity.
Yes.
And of course, you have to be, what does unlawful mean? I mean, this sounds, it sounds to me like if your charter you're doing something your charter doesn't allow, that sounds more like an administrative thing. In what sense is that unlawful?
So the specific phrase to trigger quo warranto relief is exercising a power not granted by law. I realize it's a small distinction, but the case law has held that that does apply to limitations in a corporate charter. So for example, in State versus Southern, well, no, let's give a different one. In City of Wink v. Griffith, and there's and Memorial Society.
Yeah, almost all of these cases are ancient. I mean, it does, that's the odd thing about this. You look at the Constitution, Article 4, Section 22, and that's what it says. Attorney General can inquire into charter rights and take such action, if they're from exercising any power not authorized by law. That's what it says. But then 120 years ago, they say, well, of course, it's got to be public purpose. You just can't jump into some corporate dispute between, business owners because you think they're doing that. I mean, it's got to be, your office is to protect the public, not particular investors and stuff like that. But so your argument that the public interest in this case is what?
The public interest in this case is that the state of Texas, the state legislature, made certain determinations of what activities it would agree to subsidize. and that subsidy is via tax benefits. Here, Fiel is trying to have their cake and eat it too. They're trying to make these political statements, essentially act as an action organization, and yet still be able to get tax-exempt donations for their donors.
Well, why wouldn't the remedy here be to eliminate, for them to lose their tax exempt status or something as opposed to, the forfeiture of the charter itself?
So that would be an issue for the tax comptroller. The Attorney General's authority is simply, not simply, but rather more narrowly, to address whether corporations in the state are abiding by state law and whether they are abiding by their covenants in their own charter. So it's kind of a separation of powers issue. The Texas comptroller, of course, can do what they're going to do, but we are charged with regulating corporations that violate their charter.
Does the Secretary of State cancel people's forfeit? I suppose they do if they don't pay any franchise taxes.
I believe so, again.
And is this just about franchise tax?
No, there are a number of exemptions.
So you'd have, is property tax involved in this case?
I'm not sure. So we're still at a very preliminary stage of this case. We're in the pleading stage. So it's unclear exactly what benefits Fiel is actually receiving, but the fact is that they are applying for those benefits.
Well, but in a state like Texas where there's no state income tax, the relevance of a tax-deductible contribution is my federal income taxes, because I don't have one with Texas. And can we, if we go forward on quo intro, can we cancel somebody's 501c3 and say, tell the IRS, sorry, you can't recognize those deductions? How is that going to work when all the relevance is federal income taxes?
Two responses. First, it's not just income tax. Texas Tax Code 171.063 exempts them from franchise tax. Section 151.310 exempts them from sales tax.
Little slower, hang on,
Sorry,
171.063.
these are also in our brief, but
Okay.
so these are all Texas Tax Code. The first, Section 171.063,
Got it?
is franchise tax exemption. Then Section 151.310 is sales tax. So whenever they buy anything, lease anything, they get
Exempt from sales tax too.
to enter that code. If as a government employee, you might if any procurement, you get to be exempt
Right.
from sales tax. So that's my first response. The second response is that in a quo warranto action, the only relief available is revocation of a corporate charter. So no, perhaps via injunctive relief that could be sought, but under the quo warranto action, it is charter forfeiture.
And how strict is this? I mean, is one bad Facebook post enough to lose your corporate charter, or?
No, the case law is very clear that it can't be a one-off. It has to be sustained and systematic, and that's some of the cases. Now, these are cases on the federal level talking about 501c3, but again, that standard is incorporated by Fiel's own choice into their charter. So those cases say, a one-off post here or there, perhaps saying, yay, this passed, that is not going to be enough for a violation. But putting out several newsletters, sending out calls to action to your supporters to vote, to call your congressman to tell them to vote a certain way, endorsing a candidate, or even in one case, the Branch Ministries case, all that religious group did was put out a full-page ad in the paper saying, President Clinton is an immoral man. He supports condoms for teenagers. That alone was enough to violate this standard because they were seen as telling their supporters to vote against a political candidate.
Are you aware of any case law anywhere where a corporation has violated 501c3's restrictions and they've had their charter revoked?
I'm not sure about having their charter revoked.
That's the rub, right? I just want to make sure I understand. Y'all are asking, the Attorney General of the state of Texas is asking this court to become the first one to write an opinion in the United States revoking a corporate charter for violations of 501c3.
I believe that is correct. Many other courts in Texas have agreed to revoke a charter on various grounds, including doing things such as, basically in the vein of exercising powers outside their
Yeah,
limitations.
that's basically, you're running a bank, but you didn't apply to the bank board. You're running an insurance company, but you haven't run, it's where there's a clear consumer protection interest.
There is one, I acknowledge it's not the exact same scenario, but there is one case, and it's not 120 years old, I think it's from the 70s, called Texas Alcoholic Beverage Commission versus National Sportsman Fraternal Order of Texas. And there it was talking about tax exemption, and they did ultimately, it was simply that they weren't authorized to sell alcohol, fairly minor. They were authorized to do whatever they wanted in their fraternal order, but they weren't they sought an exemption related to selling alcohol, and they said, no, that is not allowed. And in part of considering their charitable status, they did consider, quote, that they had no evidence of political activity. So that was relevant in that inquiry as well.
So what happens, let's just say this court did what the Attorney General was asking and said you have the right to go seek revocation of a corporate charter based on violations of 501c3. And then 2 years later, a case goes through federal court from IRS action saying the exact same thing is not in violation of 501c3. What happens?
Well, the important distinction is that we are not asking this court to find, as a definitive matter, that Fiel is violating 501c3. They are violating, one, their covenant in their own charter, and that is a Texas state-specific issue. Admittedly, it's the same language, but it is not 501c3. And second, that they are violating these Texas tax code provisions. So whatever the IRS is going to do, whatever is happening on the federal level, that has no impact on the state's ability to administer its own laws with regard to limitations on charters and Texas tax code.
I guess, so, let me make sure I got that right. So a federal court enforcing 501c3 regulations of whatever kind, they couldn't forfeit a Texas charter, they couldn't
That's right.
decide whether we can collect franchise taxes or state sales taxes.
That's right.
So we have to do that. They can do whatever they want to do on federal income taxes.
That's correct. See, my time has expired.
Thank you,
so-
Ms. Smith. Mr. Soltero.
Good morning, Mr. Chief Justice. May it please the court. On Appellee Fiel's behalf, we're asking the court to affirm the trial court's order finding no abuse of discretion, either in, number one, denying leave to the Attorney General's office to file the quo warranto, or two, denying temporary injunctive relief to the plaintiff. The requested relief here, as many of the questions of the panel already reveal, is unprecedented in our entire system and seeks to bypass judicial review, established process, and ignore serious federalism and other constitutional barriers to the relief they seek. Among the key issues I think that are before the court is, number one, substantively, does the statute authorize the Office of the Attorney General to bring this type of quo warranto action? And if so, what discretion does the trial court have? And what burden must the OAG shoulder? Secondly, procedurally, what must the OAG show? And then there may be some additional defenses and other issues. I think it's telling, and I want to start from a big picture before I get right into the plain language, which is how we always look at statutory construction. It's telling that in over 150 years of this great state's history, no Office of the Attorney General has claimed this type of quo warranto power, which by statute is limited, strictly construed, legislatively created with judicial oversight, and for this kind of writ. Not when Governor Abbott was Attorney General, not when Senator Cornyn was Attorney General, not when Jim Maddox was Attorney General, not even when Dan Morales was Attorney General. None, so moving to the plain.
That doesn't make it wrong. That just means they haven't done it. I mean, it does, the Constitution does say that's the Attorney General's job.
Your Honor, the Constitution includes certain quo warranto powers as part of the Attorney General's job.
Sure.
Article 22. The question is, can you take it this far? Can you misapply it this way? That's really the issue here.
Well, I have a question. Say,
Yes, Justice Ferris.
Just hypothetically, some group went out, gets a nonprofit corporate charter, and then all of a sudden raises the elephant or donkey flag and declares themselves to be an arm of a local political party and says, from now on, we're going to get our candidates elected, we're going to get our laws passed. You couldn't do this even in that circumstance.
I believe that in that hypothetical, the proper remedy would be for the Internal Revenue Service to determine that they've lost their 501c3 status.
But there's nothing the Attorney General could do.
I think that there may be a circumstance where the Attorney General, in a very extreme fact scenario, not like the one we have here, could possibly seek some type of injunctive relief. And as the trial court rightly pointed out, typically we stair-step these things. Typically, there's initially some kind of a dialogue or some kind of process where there's a letter, a cease and desist, where there's perhaps some minimal relief sought first, not coming in right out of the box and seeking forfeiture of the charter, which we consider to be essentially a death penalty.
But we see stuff, in our mail every day, direct mail solicitations, and you can give money to the 501c3, which is our educational arm, or the 501c4, which is our lobbying and filing lawsuit arm, and you choose, and when the donor chooses, you can deduct the C3, but not the C4. And as I understand, the Attorney General is saying, look, y'all can have all the protests you want, but you got to be a C4 and not a C3. And my understanding is they say your client was given that option. Why don't you change your articles by the trial judge? And they said no.
Well, Chief Justice, I think that I'm trying to understand exactly what the question is.
So the question is, obviously, they have a First Amendment right to oppose anybody they want. They can't oppose us for a couple of years, but they have First Amendment right to do that when we get around to that stage. But the deal is, for lobbying and political stuff, you have to be a 501c4. And you have to tell donors you're not going to be able to deduct your contributions. And so why is it they don't want to do that? What is the assets or the taxes that's going to be a killer if they do that?
I don't know that there are any that would be a killer or that sort of thing. Let me back up a little bit to answer your question. And I think, let me reset what I think a better view of what the landscape is.
Sure.
First of all, clearly, and I think I heard counsel for the other side say that the determination of IRS regulations is for the Internal Revenue Service and not for the Attorney General's office, number one. And so there's absolutely a remedy there to start with. And they're the ones that determine that somebody paid too much taxes, too little taxes, improper deductions, all these issues. With regards to Texas state law does not prohibit political speech. Frankly, it's corporations generally. To the contrary, we're a very robust pro-liberty, pro-First Amendment speech state across the board. And the statutes that are cited in our briefs and their briefs, none of those prohibit political communications from even 501c3 organizations. All we have to do is maintain our 501c3 status, which is a determination that is made at the federal level. So I think that while there are all kinds of hypotheticals that I think we could all imagine of perhaps some other entities going too far.
So which section of Tax Code 1118 are the protests and other things? 1118D expressly says you can't, you got to be exclusively, let me get the exact language, organized exclusively to perform religious, charitable, scientific, literary, or educational purposes, and engage exclusively in performing one or more of those. So I read in your brief, say, well, we're going to do symposia and stuff like this, but when you got big banners like this and you're standing out on the road or the sidewalk and shouting slogans and stuff, that's not a symposium. That's not a class. That's a protest. Which is fine. You're entitled to do it, but it's not exclusively a religious, charitable, or educational service, is it?
I don't know that would qualify as exclusively those things, but there's no limit it must be organized exclusively, but it doesn't mean that it's not allowed to perform any other functions. It doesn't proscribe every other function. It says it must be organized for that purpose, but it can do other things. And if we go back to, I think one of the things that we laid out towards the end of our brief that I think I would like to summarize for the court that might be helpful is the contrast between the proposal that's being made by the Office of the Attorney General as to how to apply 501c3 standards and the actual federal procedures that are well established and have governed for decades. On the one hand, the Attorney General would suggest that you have zero tolerance for political speech. The federal procedure actually allows for political speech by 501c3s within limits, as long as it doesn't go too far. And that's a factual determination that's typically made. In fact, they allow lobbying, which is probably the most ultimate political speech you can think of, as long as it doesn't become excessive. Secondly, the Attorney General's proposal relies exclusively on the social media, the postings, just things of that nature that you've seen, many of which go back long beyond the 3-year period that the IRS provides for. By contrast, the IRS applies a holistic review. What does the entity do? And we have a record here, and what my client does is provide all kinds of social services, information, provide support to all types of people in the community. I know the panel is very familiar, as I am, with Houston, and they provide disaster relief when we happen to get things of that nature. So and that's undisputed by the Attorney General's office, that what we do, all these things for the community beyond these exhibits that you see in the record. So from a holistic review, it's certainly well compliant with 501c3. The Attorney General would lower the bar and would prohibit criticizing elected officials who are not campaigning. The IRS expressly allows criticism of officials who are not campaigning. In other words, while they're in office, the federal tax code allows that to happen by 501c3s. The Attorney General's office proposes that you can bring this quo warranto type procedure against people they don't like, and in this case, somebody who happens to be a plaintiff in a federal lawsuit against Mr. Paxton himself in his official capacity, and try to seek to forfeit their charter immediately, whereas the federal procedure allows for a process, a notice, an opportunity to cure, and an opportunity to be heard.
Mr. Solterra, my concern in a lot of this case is just the requested remedy. Like, let's assume for a second that Fiel, and I apologize, I know our pronunciation was probably affected by my last name in some ways, but the remedy they're seeking, the corporate charter revocation, do you agree, and I'm sure you don't, but I just want to explain why, that if you're in violation, just assume hypothetically, if Fiel was in violation of 501c3 and its incorporation into the charter, that the Attorney General can seek revocation of your charter?
Let me answer it this way, and I understand your question, and I want to work through and get to your, number one, the Attorney General's office has no right, power, or authority to try to enforce an action based on alleged violations of federal law. Number two, because of Texas law and Texas's public policy choices, we're absolutely allowed to do what we've done. And Fiel has never been accused of any crime, has not been convicted of any crime, has not been found of any wrongdoing up to now. But to answer your question directly, if there was found to be a violation of a law, like for instance in the case law, for instance the case of one of my preferred cases in reviewing this is from Houston, where Mr. McPherson wanted to run a bail bonds company, but didn't want to follow the regulations that are provided and didn't want to get a bond with the insurance commissioner. In that instance, it would be absolutely appropriate for the Attorney General's office to come in here and seek revocation of somebody who fails to comply with the basic rules. And typically, I like to analogize this a little bit to special appearance. There are some very complicated things that can be looked at in the special appearance context. But when it comes to whether somebody's registered in a state and incorporated and whether it's their principal place of business, that is a binary test and very simple. They are or they're not. And that's the nature of this quo warranto statute for the most part. I don't know if that answered your question. And so in those circumstances, I think seeking judicial forfeiture would be appropriate.
Yeah, it seems like to me that they're hanging their hat on the fact that the corporate charter or the governing documents incorporated the language from 501c3 and the CFR. Is it the case, and I don't know the answer to this, that every charitable organization has similar language in their charter? Or is this specific to this one, or do you know?
I'm not a corporate lawyer, I don't know, but I will say this. If we look at the actual language of the charter, which they've cited in part, and they talk about a red line, but they don't read the rest of it. They don't read the end. Because if you read to the end of section H, it says some of the things they say, and it says, including any political campaign on behalf of any candidate for public office, except as allowed by the Internal Revenue Code and its regulations. And so that by itself puts it back under the applicable federal standards. And it is not you can't engage in any political speech, you can't petition to a court for relief. None of that stuff is contrary to the Internal Revenue Code and its regulations, or in this instance, Fiel's charter. And so factually, that's part of the problem with the Attorney General's case here.
Do you have to get be a 501c3, allow tax deduction to folks, do you have to say that in your charter? Do you know?
I don't know
We
that,
looked
Chief
around and
Justice.
couldn't find anything.
I'm not aware of whether you need to include that formal language once you make the proper applications and you're granted that status.
So your argument, just to follow up on my question and your answer, your argument is, yes, this is in our charter, but by the charter's very terms, if you, court, are going to take the Attorney General's argument and run with it, you would have to decide that it's actually in violation under IRS regulations. We would have to decide if the IRS would decide, so to speak, that it's in violation.
That's exactly right. And that's probably a better way to articulate what I was trying to say.
I don't feel like I articulated it very well, but
But
I was trying.
That's exactly right. The IRS standards are incorporated into the charter that they're saying that we're not complying with, but we're complying with the IRS standards.
So I was just looking through the record. Is the comment that was made about delivering somebody's ticket out of the White House, are you arguing that that doesn't run afoul of any IRS regulations, or that would just be like a de minimis violation? Or just help us out, walk through the facts a little bit.
Understood, and I'm going to
Sure.
answer that question directly. First of all, it is for the IRS to decide that issue, but that may be something that the IRS would certainly inquire about possibly and determine whether that is de minimis or consistent with the wide range of activities that they allow that are permissible. I mean, is that a stray remark, an occasional thing that was made, or is this a pattern of some kind of activity that reaches the level that they typically look at and that the cases indicate?
Okay.
So the other cases that I wanted to speak briefly with the court about were in fact, and I don't think that the court needs to get to this issue at all for all the reasons we've been discussing, that it's not authorized, that it's for the Internal Revenue Service, that it's preempted. But there's also the issue of unequal enforcement. And in that manner, the Branch Ministries case that counsel referenced in her argument, which is in the Attorney General's brief at page 19 and 28, notes that in the event that there's allegations of disparate enforcement, and in that case it involved statements that some 501c3 made about President candidate Clinton, the court says expressly that there would be the opportunity for discovery and to see how the IRS has applied this in other contexts, and that even though they didn't have significant proof at the time of the TI hearing, that did not defeat the fact that they would have a colorable claim of unfair, unequal treatment, which is, we believe here, on its face at issue, and then certainly would be part of the defense. unless the court has, oh, and one other thing, in addition, and I know it's been raised in the argument, but I want to make sure I don't miss it. In addition to there being a complete federal system for addressing the complaints that they have, there are also these other state law remedies. There's the Comptroller's Office, there's the Secretary of State, and so there are other avenues that the state has if they have concerns about any nonprofit or other corporation subject to its jurisdiction. And again, just I'm not sure what else is going to come up, and I want to make sure I don't forget anything. There's some reference in the Attorney General's brief about some cases from other jurisdictions. Well, other jurisdictions have different statutes. There, as Chief Justice Brister pointed out, we don't have an income tax. Other states do have an income tax. Other states, like New York, have apparently adopted the IRS standards in full. Texas has not done that. So there's a lot of differences, and so we're here because Texas law does not prohibit the conduct that Fiel engaged in and does not give the Attorney General the right to bring this type of action. So for all those reasons, and those in our brief, we would respectfully request that you affirm and on the Annunciation House issue, I don't think this issue was teed up in that argument as clearly as I think it is in this case, and I think it's very important for the jurisprudence of the state to have an opinion on this, and we would respectfully request an affirmance of the trial court's orders on both grounds.
Thank you, Mr. Soltero.
Thank you, Chief Justice.
Rebuttal?
Yes.
Smith, before you jump in, I want you to address Mr. Sotero's argument that there's a selective reading of the charter, that subsection H of the charter basically incorporates IRS rules and regulations, and that those would control. Do you agree with that?
I do not believe that they would control, but additionally to rebut some of what was going on with the discussion of the IRS statements. So counsel said that under IRS regulations, it has to be a substantial amount of activity. Well, that's only partly true. The substantial amount of activity attaches to the advocation on behalf of or against legislation. So if you have insubstantial lobbying with regard to legislation, that doesn't violate the rule. But the text of the IRS rule is very clear that any advocacy for or against a particular candidate does violate that rule. And that's why in the branch ministry's case, a single advertisement was sufficient to violate that rule.
But aren't we wading off into, let me start over. One of my concerns, I remember taking federal tax when I was here at this law school, and I never wanted to see it again.
Likewise.
Aren't you asking us to basically become a mini tax court in Texas where, it's like the last case where you have TCEQ that has expertise. The IRS and the tax courts have expertise. We don't. So if we decided for the AG here, are we opening ourselves up to basically threatening any 501c3 that the Attorney General doesn't like their politics, that they're going to be coming here and asking us to make tax decisions?
No, that's not a risk. First, I'll just address we did not go after Fiel because of their politics. This case was brought because they were violating their own charter and several provisions of state law. And there's no evidence in the record about retaliation. But to address the substance of your question, this case is still at a very preliminary posture. We're just deciding, can the quo warranto action even be filed? Once it's filed, there will be discovery, there will be judicial review, that is not correct. There will be the entire normal civil process, and then the district court will determine, whether these things are violations. They can testify perhaps about other activities they're doing that offset these statements. But at this stage, the only inquiry is whether, and this is from the City of Doublehorn case, it says the only inquiry is if the state's allegations taken as true state a cause of action for quo warranto. If that is true, the trial court has no discretion but to grant leave. So on the face of our petition, we have alleged, and with substantial attachments as evidence, that they have engaged in substantial violations of their charter, that they have engaged in violations of Texas law. And what we have alleged is sufficient to state a cause of action. At this point in the proceeding, that is the only question. The Supreme Court of Texas has held once that is met, the trial court has no discretion but to grant leave. I'd like to address a couple of other things that came up in my friend's argument, specifically regarding the limitations on political speech. So this is a limitation that Fiel put on its own political speech. This is not a state-imposed limitation. They agreed to do this, and they violated that agreement. And the Supreme Court of the United States has been very clear in the Regan versus Tax Foundation case, that is not a First Amendment violation. Secondly, again, as I mentioned, whether there's other activities going on, that is a factual determination that will happen at discovery. We are still very early on at the pleading stage. And there's the last thing I'll note, talking about the out-of-state cases in New York and Tennessee. The New York cases actually show that New York has not adopted a 501c3 standard. The charitable organization argued that they could not get their state tax exemption revoked because they were complying with 501c3, and the IRS said they were. The New York court held that doesn't matter. Whether or not the IRS says you comply with 501c3 has no bearing on our state court determinations, and there was a similar inquiry in the Tennessee case. I ask that this court reverse and remand. Thank you.
Thank you, Ms. Smith. Counsel? In just a moment, we'll be adjourning the court. As I said earlier, the attorneys are free to leave. Thank you for your help today. Any students that would like to have questions, we're going to retire and get rid of the robes. Be happy to come out, answer. Some of our staff is here as well, answer questions about what it would be like working, interning, clerking at an appellate court. And we'll be happy to hang around for a few minutes and discuss that for if any of you are interested. At this point then, the marshal will adjourn the court.
All rise.